Good morning, everyone. Uh, Good morning, CJ Castro, uh, PJ Nara, Judge Tenorio, and Justice Enos, and as well as Justice Manglonia. Thank you all for being here and bringing your team to present your Justice Judge Tenorio. But thank you all for being here to present the budget request that'll be made by the judicial system. With that, we do have a number of representatives for quorum. Let me introduce my members. I have Rep. Atal, Vice Chair. On the floor, we have the Chair for JGO, Rep. Marissa Flores. To her left, we have Representative Manny Castro. And to his left, we have Representative Roman Beneventi. And across the aisle, we have Representative John Posablan. And to his left, we have Representative Joe Flores. Flores. With that, thank you all again for being present today. And I will need a motion to adopt today's agenda. There has been motion, has been seconded. All those in favor say aye. All those opposed say nay. The ayes have it. Moving on to item 3. Is there anybody in the gallery that would like to comment on the request made by the courts for their annual budget? Floor is open. Please state your name, sir.
Is it on? Oh, thanks. Once again, I'm Joey Nicholas. I'm here on behalf of the CNMI Bar Association. Good morning, Chairman Yumel and members of the House Ways and Means Committee. My name is Joey Nicholas, and I'm here today on behalf of the CNMI Bar Association in support of the Judiciary's request for over $200,000 for a new account category for indigent defense. The right to counsel is a fundamental aspect of our justice system, enshrined in the Sixth Amendment of the United States Constitution. The U.S. Supreme Court's landmark decision in Gideon v. Wainwright solidified the principle by holding that the state must provide an attorney to defendants in criminal cases who simply cannot afford one. This decision underscored that a fair trial is impossible without adequate legal representation, a cornerstone of our judicial system that ensures the protection of individual rights against government overreach and abuse. In the CNMI, the right to counsel applies to adults who are charged with a felony or misdemeanor, to juveniles charged with juvenile delinquency by the commission of an act which, if committed by an adult, would be a misdemeanor or felony, in contempt of court proceedings in which the defendant is in jeopardy of incarceration, in probation revocation proceedings, in involuntary civil commitment proceedings, and any other proceedings where the court finds that the indigent person has a constitutional or statutory right to representation. In the Commonwealth, the CNMI Public Defender's Office and the Micronesian Legal Services Corporation serve as the primary defenders of indigent defendants or indigent individuals in criminal and civil cases, respectively. However, there are instances where these offices face conflicts of interest or are otherwise unable to represent certain parties. In such cases, it is imperative that funds are available to hire private counsel to ensure that no individual is left without representation. If attorneys in the Public Defender's Office or Micronesian Legal Services Corporation are not available due to conflict of interest or other inability that prevents effective representation in accordance with constitutional and professional standards, the court designates counsel from a roster of private attorneys approved by the court. The court appoints separate counsel for indigent defendants having interests that cannot be properly represented by the same counsel. Counsel appointed shall continue to act for the defendant throughout the proceedings in the court in which the appointment is made and in many subsequent proceedings or appeals. An adequately funded public defense system is not merely a constitutional requirement, but a crucial component of a fair and effective judicial system. Ensuring that indigent defendants and civil parties have access to competent legal representation helps maintain public confidence in our courts and promotes the fair administration of justice. Moreover, it safeguards against the risk of wrongful convictions and other miscarriages of justice, which can result in significant human and financial costs. When the defense system is underfunded, it leads to overburdened public defenders, delays in judicial process, and a potential increase in wrongful convictions. These outcomes undermine the integrity of our judicial system and erode public trust. Conversely, when we invest in indigent defense, we promote efficiency and fairness within our courts, which benefits society as a whole. Therefore, on behalf of the Northern Mariana Islands Bar Association, we urge the House Ways and Means Committee and the House of Representatives as a whole to support the Judiciary's request for funding indigent defense in the amount of over $200,000. By doing so, we uphold the principles established in Gideon v. Wainwright, and we reinforce our commitment to justice for all members of our community, regardless of their financial means. Thank you, Mr. Chairman and members, for your time and your consideration.
Thank you, Council St. Nicholas. Any other person in the gallery? Being there's none, we'll move on to the statement or presentation that will be made by our Chief Justice, Your Honor Castro. You have the floor.
Thank you, Mr. Chairman. Buenas ako fa dayan tirawami para todos si members si Pisong Kongreso paugunawagan. First, let me extend a dangkuluna si Jus Masi, Governor. I know you're looking down at us right now. Dangkuluna si Jus Masi. And also Lieutenant Governor Apatang. Senate President Edith De Leon Guerrero and members of the Senate, Speaker Edmund Villagomez, and members of the House for helping, assisting the third branch of our government to survive the fiscal tsunami that is still with us today. Without your assistance, the judiciary would have sank faster than the Titanic. Our Constitution requires me to submit a budget that accurately reflects the needs of the courts on Saipan, Tinian, and Rhoda. And to do this, we asked all the divisions in the judiciary to submit their needs for FY 2025. An in-house committee of the judiciary then went through these submissions, and thereafter Presiding Judge Naraha and I submitted the budget now before you. Some, of course, of my staff and maybe some judges were not very happy of our submission because we did not incorporate each and every request they made. Had PJ Naraha and I incorporated every request made from Rota, Tinian, and Saipan, the judiciary's budget requests would undoubtedly be more than $15 million now before you. The executive branch has fulfilled its constitutional duty by trying to proportionately allocate available funds. It is now before you, the legislative branch, to carefully examine whether we, the judiciary, have justified our FY 2025 budget submission. Our dedicated and hardworking management team stands ready to answer any questions that you may have on our submission. With that, I now respectfully ask and turn the floor over to Presiding Judge Naroha.
Thank you, Chief Justice Castro. Good morning, Mr. Chairman Yumo, and members of this House Ways and Means Committee. Thank you for the opportunity to speak to you this morning. Associate Judge Kim Tenorio, Associate Judge Linian Tenorio, and I will be covering different aspects of the Superior Court matters this morning. To start, it is important to note that in 2023 alone, the Superior Court received a total of 119 case filings, with an average of 14 new cases filing per day. Out of the 5,119, 2023 saw the highest number of civil and family court filings in the past 5 years. These numbers do not account for the numerous pending cases that have been carried over from previous years, as well as anticipated jury trial costs and court-appointed attorney costs. These numbers also highlights the Superior Court divisions continuing to remain extremely understaffed, which is why we continue to come before this body requesting for funding to meet our critical FTE needs. Our Office of Adult Probation Supervision, for example, is in dire needs of additional staffing. According to American Probation and Parole Association, best practice standards indicate that in order for probation to be effective, one probation officer should be responsible for supervising around 30 probationers. Personally, at the Office of Adult Probation Services, however, one probation officer supervises between 60 to 80 probationers a year. The traffic officer alone supervises about 200 probationers per year. Recently, the Office of Adult Probation has joined efforts with the Northern Marianas Technical Institute to allow probationers the opportunity to take classes in lieu of community work service so that they may attain trade skills that they can use to gain employment in our workforce. These endeavors will begin this upcoming semester with courses related to construction. We are also seeking to implement a re-entry program at the Adult Office Probation, which will provide probation officers with the resources and tools they need to better assist clients considered high risk and or repeat offenders in our community. We hope that this will reduce crimes rates and recidivism and increase public safety. Additionally, as the chairman of the Traffic Records Coordinating Committee, a program under the Department of Public Safety, the DPS Commissioner Macaranas and I have been entertaining the idea of having the judiciary and DPS share revenues collected from traffic fees and fines. I've also reached out to Congressman J.P. Sablan, who is in support of this initiative. I have also informally invited Congresswoman Marisa Flores to join in. I look forward to discussing this matter further with them and other legislators. There are more specialty courts that the Superior Court is exploring. For each specialty court established, a full-time deputy clerk is needed. We are in dire need of not only additional staffing for the court of court office, but also need to increase their salary as our deputy clerk once salaries remain at 24,000 a year. For many clerks, after they are trained and gain valuable experience, federal courts or other courts in the mainland have lured them away to better and greener pasture. We continue to lose these hardworking professionals that we have trained because of competitive salaries elsewhere. Thus, we are unable to maintain stability amongst our clerk of court office staff. With the expansion of our specialty court dockets and the establishment of additional specialty courts, which is the national trend in criminal justice reform, there is a need to continue building and preserving our justice building fund. Funding that the judiciary has been difficult, and although we continue to look to federal funding to supplement our judicial building fund, we hope to raise sufficient funding resources. We need to eventually build a building where we can house our staffing for our treatment courts, such as drug court and mental health court, the Office of Adult Probation, and juvenile court staff. At the suggestion of DPS Commissioner Macaranas, we would like to include a classroom-like training center equipped with modern technologies for our law enforcement cadets from the Judiciary, DPS, DOC, Custom, and other government agencies. I thank you for your time and now ask to shift your attention to Judge Kim Tenori, who will be covering drug court and family court matters, and Judge Lina Tenori, who will be covering mental health court matters. Thank you again, and Sidus Masi.
Good morning, honorable members, chairman. Thank you for having us here today to hear our budgetary needs for FY 2025. I'll just take a moment or two to quickly update you on the dockets I preside over and programs I am exploring, which will give you a better idea of how we spend funds appropriated and how we continue to seek other funding sources. Also, I do have some stats prepared, but I'll save them for any questions you may have about a certain program, division, or docket. So a quick update on drug court. We currently have, I think, 32 participants, of which 7 are from Tinian, the most we've ever had from Tinian. And as a result of the higher number of participants we have from Tinian, we are starting to shift a little bit our supervision and services that we provide to these participants, because ultimately the goal is to have them relocate back home and immerse themselves in the community that they came from. And so we are now starting to train Tinian and Rhoda marshals to drug test and to conduct effective supervision for our participants, and also allow Tinian and Rhoda participants to travel home. Unfortunately, at this time, we don't have any Rhoda participants, but that is not going to deter us from actively training our marshals there in Rhoda to effectively drug test and supervise. And in this process, we're also going to do more outreach with Tinian and Rhoda DPS so that they too can assist us and can be part of this process. For family court, so the first slide you saw was outside Guma Justicia in the evening, and that was taken the first night that we conducted night court. We started that in November of 2023 in response to mainly parents in the private sector who, when they take time off to come to a court hearing regarding custody or support, child support, they have to take time off clearly and are not being compensated when they leave work to come to court. And so in response to that, we started night court. And so we do that once a month. It's been very effective. And we conduct hearings from 5 p.m. to as late as 9 p.m. The challenge we face in family court is this additional service in addition to everything else we do and the lack of staff. Right now, we have one manager and one staff. And this morning, before I came here today, I accepted my 278th family court case. So by the end of this year, we'll be looking close to 600 family court cases handled by a manager and one staff. And so we have asked in the past and will continue to ask for additional help for family court so that we can effectively serve our community. Also in this second quarter, I know that the family court staff entertained over 1,000 clients who have come to court either asking for questions or asking for certain forms ready to file different family court cases. The other update I have for family court is because of, we know drug court is successful and it's working, but that's the criminal aspect. How about those who don't commit crimes but are having issues with drug abuse? So, and these mainly come in through pursuant to wardship cases where children are removed from the home because their parents are engaging in drug use. And of course, the goal in family court is always reunification for the children with their parents in wardship cases. And so I've recently applied for a family treatment court grant in the amount of $750,000. I was fortunate enough to meet some of the deciding team in Anaheim when I went there for my drug court training. And they've assured me that they will give it the attention that it needs, our application, and hopefully grant us our request. This grant will allow us to work with PSS, DYS, DPS, our team, DOC, the Hope Recovery Center, CGC, so that we can wrap around services for the entire family, for the children, the parents, so that we ensure that the kids are still going to school, they're getting their immunization records updated, they are seeing counselors as needed, that they are in a safe home, and that mom and dad are getting the treatment they need, so ultimately they can be a family unit again. The uniqueness of this grant, unlike some of the other grants we've applied for, is this grant allows us to hire staff. And so we've included requests for FTEs in this grant. It's for 3 years. And if we successfully implement this, they will grant us additional 3 years. So I guess the overarching theme of the dockets and divisions I oversee in a nutshell is that, prison doesn't work. Prison doesn't work. And part of what a judge considers in deciding sentences includes incapacitation, deterrence, retribution, rehabilitation. So we got the incapacitation and deterrence part by way of prison, but folks serve their sentences and they are released. When they are released without proper planning and services, they will reoffend and come back into the criminal justice system. So that needs to change, and that's why treatment courts. Why else? Because we save money. It's cheaper to treat than to incarcerate. And we, as a result, reduce recidivism. Why treatment courts? Because drugs are not going away, because drug dealers and manufacturers are always 10 steps ahead of us combating the drug epidemic. And I just want to bring your attention to one thing. When I started drug court 8 years ago, it was just kind of meth, marijuana, alcohol. Now we are testing positive for other substances, and that's scary. And I just want to mention that as of June 26, Guam reported 3 fentanyl deaths That is very alarming. And if Guam has 3 fentanyl deaths, I guarantee that fentanyl is here already. And fentanyl is a powerful synthetic opioid that is up to 50 times stronger than heroin and 100 times stronger than morphine. Just 2 milligrams of fentanyl equal to 10 to 15 grains of table salt, and that's a lethal dose. And so I'm very passionate, of course, about my treatment courts, but I just would like for this body to consider, when considering the budget, the adequate budgeting for treatment courts in the judiciary. Thank you.
Good morning, Mr. Chairman and members of the Ways and Means Committee. I'm Lillian Ada Tenorio, in case you didn't catch that. I've been here in different capacities, but I'm here in my current capacity, having been confirmed this past February by the Senate as Associate Judge. Now, I'm here to present on the mental health court docket. The presiding judge and I have co-sharing duties over this docket, and I'm privileged to present on his behalf and also on behalf of the hardworking men and women in the criminal justice agencies and health professionals, including the mental health docket staff, who are part of this newest treatment program in the Superior Court. Now, it was established in July 2021, and it's modeled after the drug court. The mental health court is also a collaborative docket that brings together criminal justice agencies such as DPS, the Office of the Attorney General Criminal Division, the Public Defender's Office, and the Department of Corrections, as well as the Commonwealth Health Care Center through its Community Guidance Center and the health professionals. And the whole goal and objective is to identify participants with underlying mental health issues and provide specific services and treatment for each participant. This is an individualized type program. It is intensive. Now, eligible veterans and service members are also included in this docket. The emphasis is on a problem-solving model and connecting participants to rehabilitative services and support networks within the Commonwealth. As Judge Kim Tenorio mentioned, the traditional way of charging someone, putting them in jail, and then releasing them again has not worked. And so therefore, the emphasis of a lot of courts throughout the nation is to look at treatment courts as an alternative way of dealing with criminal behavior. Now, the goal of mental health court is to support the participants who are part of our program to ensure their successful returns to society and to reduce recidivism. Also, we want to increase public safety and improve a participant's quality of life. As I mentioned, it is an intensive case management approach. I have hands-on on each of the cases that are before the mental health court docket. And it's intensive supervision to these individuals who have committed a misdemeanor or felony offense as a direct result of their mental health systems or intellectual and developmental disabilities. Now, we all know that there is a shortage of behavioral health services here in the Commonwealth, but I can confirm that the individuals who are a part of our team are diligent, they're committed, and they bring to our meetings and hearings their perspective and recommendations to assist the participants. It's an earnest effort, and each recommendation, each comment, each input and feedback is taken under consideration. Now, a total of 5 participants have been accepted, and there are currently 3 active participants, and there are others who are being assessed for eligibility. Even with the current number of participants, the work of the mental health court continues with under the intensive case management approach. We hold hearings, we conduct case management meetings. There is medication management sessions that the participants are referred to, counseling sessions, and the TLC day programs at CGC. The participants are held accountable under our policies and procedures. Sanctions are issued when warranted, and rewards with incentives are given to a deserving participant. Drug Testing is routine to treat those with co-occurring conditions. They have both a drug addiction as well as a mental health condition, and that is treated under the mental health court as well. Participants are required to attend therapeutic sessions, and the mental health court staff assists in arranging for those sessions and transporting them if necessary. A great deal, or a substantial number, are homeless, without an address, without means of transportation. And so we do our best to make sure that that they make it to their counseling sessions. That's all part of the wraparound services that Judge Kim Tenorio mentions. It is part of treatment court and has proven to be very essential and important. That's why when I say it's intensive, it's really intensive. Records are kept diligently of each participant. That's for data gathering. That is also required under our grant. And also for ourselves to know where we are at, whether or not we are succeeding in our objectives, and to look into the future of what we can do to reach out and ensure that we have the participants included in the mental health court docket. Now, there are two primary sources of funding. As you know, federal grants is a big part of this. It's dispersed annually for the next 3 years. It's under the JMHC grant and the Burn grant, which handles veterans, includes them within the docket. And we also have the annual appropriation from the legislature. Thank you. For last year, this current fiscal year, 296, I may be wrong, but there was appropriation, a significant appropriation, and a good chunk of that appropriation funded the personnel costs for those under the mental health court docket. Federal grants have been used for operational expenses, training, and so on. Now, we ask that that the Ways and Means Committee support the submission of the court to fund again the personnel costs that have been included in the budget for the judicial branch. I just want to point out also that the planning phase of our grant for mental health court will end this year, and then the following year we will begin implementation. That will depend on the planning and implementation guide that has to be submitted, which we hope to do so by September of this year. And we have with us the subrecipient grant of the grant, a mental health agency, West Care Pacific Islands, Inc., that will assist us in supplementing what we have already with the partnering folks at CGC and the Cagman Healthcare Center. They will provide clinical treatment for mental health and for substance use disorders. As I mentioned, mental health comes with it, often occurring condition with addiction, alcohol, meth, and THC. Now, the screening tools, what we're looking at in the next year is improving or ensuring that our partners, DOC in particular, have screening tools for identifying individuals with mental health, substance abuse, and also to indicate whether the folks that they are booking, they're being booked and being placed in DOC, are veterans. This will assist us in identifying early those who may possibly qualify for mental health court participation, our treatment and services that we provide. We also want to look at perhaps assisting adult probation as well, and helping to screen for issues that may come up that will require their probationers' assistance in therapy and counseling to assist their reentry back into a meaningful and productive work life. But one of the things that we are looking at, and this is with presiding judges' initiative, is to look at the youth. Because one of the things that we noticed in our reviewing data, relevant data, is something that was filed by PSS. It's a survey that was filed with the CDC And it shows a very alarming set of statistics concerning the well-being, the mental well-being of our youth. And as these folks, they are in need of assistance. And we would like to also work with DYS, in providing mental health and behavioral screening for juveniles pre-adjudication in the diversion program. Right now, what DYS has is it has screening for post-adjudication, but not pre. So we want to see whether we can be of help. The mental health court could be of help in providing and assisting them and supporting them in their efforts to provide some sort of screening tool early on, and not wait until afterwards, but early on if they need treatment and counseling as part of their diversion program. Mental health, even though we may have a limited amount of participants, we are looking at our own policies and procedures to see whether there's a need to tweak and adjust a few things to make sure that we are covering the folks that we need to cover, that they are able to avail, that they can participate in the docket and be part of the treatment and counseling services that we provide participants. So I ask for the help of the Ways and Means and support for the mental health court program and the appropriation identified by the judicial branch. Thank you.
Good morning, Chairman Yumo and Vice Chairman Atta, members of the committee. My name is Justice John Mangolia, and I would like to say that in June of 2023, last year, we provided highlights of the accomplishments of the judiciary. And this year, recently, we've had quite a few successes also. In fact, we are celebrating our 35th anniversary since the signing of the Judicial Reorganization Act, 35 years anniversary. And it gave us the opportunity, the past few months to just reflect on the judiciary and the Commonwealth as a whole. What are our current work and also our future trajectory for the judiciary? So actually in planning for the events, we've been looking at the strategic plan for the judiciary. Over the course of 2 years, we've had legislative and executive input in developing our strategic plan, which we published in December of 2023. And that brings us, if you can see at the monitor, it will bring us to 2028. It's a 5-year plan. And so this plan, if you take a look at the 7 goals, we've thought hard about all of these goals. And you heard PJ Naraha, Judge Kim Tenorio, and Judge Ada Tenorio talk about treatment courts. And we see that in goal number 3, treatment courts. We heard PJ also talk about the treatment court building, and that is included in goal 7. And we are so fortunate to have a bar representative, JP St. Nicholas, talk about the need for indigent defense funding, and that you can find that in goal 1, access to justice. So these are all important to the judiciary. If you remember, I think, just as in any government unit or organization, there has to be a plan. And I recall that I think it was in April 2020, 4 years ago, when there was a CNMI fiscal crisis summit. I believe Chairman Atto had a prominent role in that. I remember you conducted one of the meetings. I remember the task force was comprised of the current Secretary of Finance, Narita, and Management and Budget, Vicky Villagomez. They were part of the task force. And they developed some plan, or they considered some proposed reforms to get the CNMI out of this economic rut back in 2020 before the $500 million arrived, but we're still in this economic rut. So just as the executive branch and the legislative branch have their own plans, so too does the judiciary has its own strategic plan. And this is our Bible for the next 5 years. And this strategic plan, we have timelines, deadlines. In November of this year, there's going to be a report. How do we measure our progress? And so all of these, the measurements, the analytics, they are all reliant on budgeting. So we ask for the legislative and the executive branch to continue to assist the smallest branch of government. But let me just try to go through the goals here as just as a summary. Goal 1 is we're trying to ensure access to justice. Goal 2 is to facilitate fair and timely case resolution. We want to be able to make sure that those cases that are filed are processed timely and efficiently through the system. But without adequate staffing, that is a very difficult goal to achieve. But we're trying our best with the limited resources that have been provided to the judiciary. Goal 3, as I mentioned, is to advance specialized treatment court services. And we have sought, as Judge Kim Tenori and Judge Ada Tenorio mentioned, federal funding as additional resources. Goal 4, implement adaptive technology. And this is one of my, I guess, main involvement with the judiciary. Last year, we presented that e-recording project is on its way, and we are happy to report that by September or October this year, all of the land documents in the recorder's office will be digitized. We're talking about over 55,000 files of land documents. You will be able to just search online for any land document that you want. This is hundreds and hundreds of thousands of documents in the 55,000 files. The maps that as we reported last year, they're all digitized. I think about 10,000 maps. In about a month or two, we will launch a feature in the recorder's office called the land notification. If there is any transaction about you as a grantor or you as a grantee or a specific land that you want, an alert system, there's an alert system to pop up to alert you whether there's some activity going on with your property or with your name. So you will be able to get that feature in a couple of months. So those are the accomplishments of the judiciary. The other technology accomplishment that we fulfilled is, or we will soon fulfill, is the e-court case management system and the e-supervision for probation in all our treatment courts. So any document that's filed by an attorney or by a party, you would have instant notification, and the clerks will set the calendar instantly. So why do we have these technological advances, and why do we even get into it knowing that there's, it's a long process, tedious process, and it involves some funding? Well, because we don't have the personnel. In the clerk's office, you have 5-6 people there to handle, as PJ mentioned, over 5,000 new filings in 2023, in addition to pending cases. Less than 10 employees in the clerk's office to handle that. That's an incredible task for our personnel at the clerk's office. And thank you to Pat Diaz for handling that office efficiently, despite the limited personnel and funding. The other thing that we will soon have is e-citation. We mentioned that briefly last June, and we are working closely with the Department of Public Safety, and we hope to implement that this year, now that I heard that the procurement papers have been processed with the DOF Procurement Division. So what does that mean? It means that traffic citations will be electronically filed on Beach Road or in Middle Road or in Songsong Road and San Jose Tidien, and it will get processed instantaneously into the system. And court scheduling for these cases will be almost automatic. And if the whoever cited wants to pay, that day, he can do so with the e-payment portal that we will launch. So those are the things that we're getting into. We're really excited about this technology again because there's limited resources of funding from the local government, and thanks to the help of ARPA, we were able to use the funding that was allocated to the judiciary. And moving on to after goal 4, of course, is goal 5, and that is efficient and professional workplace. We continue to have our staff trained locally, and this year we've been able to send some of our folks to the different training programs for procurement, accounting, and drug court, mental health court, where there is federal funding available. Goal 6 is to foster civic engagement. And what have we done in recent months? We've reached out to the schools. The courts have been holding hearings in Tinian and Rhoda. We've had tours from the different schools on all 3 islands. We're very active in schools because we know that we want to preempt any wrongdoings and any involvement with drugs from our young folks. We try to educate them about the legal system and how our government works. And I think we've been very successful. This year, we saw an uptick in court tours by all the schools in the CNMI. In fact, just 2 or 3 weeks ago, we had about 100 children visit the Gumosticia, and the week before that, I believe there was also another group. So we're going to continue doing that, promoting the judiciary through education. Goal 7 is capital improvements and renovations. We could still want to build our data center to house the millions of dollars of equipment that we've invested for technology. And I hope that we've reserved some of our ARPA fundings, but of course that's still up in the air as to ARPA. But we hope that comes through. And what is the anyway, I know that you folks are probably very excited to ask us your questions, and we will be happy to provide additional information. We have a lot of data, and our staff is ready to show you all the slides, the information that you may request, and we hope that we can answer them. All right. So, Justice Enos.
Thank you. Thank you. Good morning, Chairman Yumo and the honorable members of the legislature in this committee. So, as you recall, last year when we appeared at around this time to do our budget presentation, we announced that we'll be changing our case management system at the court and adding electronic citation to what's going on between the officers and the public out there when issuing paper citation. And also we gave you an update on the establishment and the adoption of rules dealing with e-recording. So by way of an update, and in addition to what Justice Manglonia has just mentioned on these 3 items, I want to say that the current case management system, which is JustWare, has met its end of life. And so we will be moving on to eCourt. That is the name of the new system. Where are we on eCourts? I think we are very close to completing that contract with them in terms of the development of the program. We started this project back in May 2021. We've issued the notice to proceed with Journal Technology in 2022. We had a kickoff meeting in December 2022. And then we are looking at a go live date in just a couple of months at around September 16, 2024.
This e-court case management system also has different modules, and one of those modules is e-supervision. That will be the case management system of the adult probation office, and the second module would be the e-citation. Uh, Justice Manglonia explained the e-recording and e-citation, but what I'll do is just add on to that. As far as e-recording is concerned, in the 3 months time that we've operated e-recording, we have collected around $9,750 for the full year. Last year, we collected around $119,000. And for the half year that we've been recording documents, this year we collected a little bit just over $80,000. On e-citation, no, what I want to say is that e-citation partly addresses the current situation that we have when citations are issued to tourists or visitors and they get ticketed out there. No, because of e-citation being integrated into e-courts, violators, especially our visitors, they'll be able to pay the payable offenses wherever they're at. They can go back to Japan or any of the Asian countries or the US mainland, and they'll be able to pay the fines from wherever they're at. So I think those are the benefits of e-citation. And I thank you for your time. I will now ask Sonia to move on with her presentation.
Thank you, Your
Director of
Honors.
Courts, Sonia Camacho.
Thank you, Your Honors. Good morning, honorable members of the Committee on Ways and Means. Thank you for the opportunity to come before you today to discuss the Judiciary's budget proposal. In addition to the members of the bench present with us that you have heard from, we also have members of our leadership team who are here to assist with any questions you may have concerning our different offices. They are Clerk of the Supreme Court, Judy Aldan, Clerk of the Superior Court, Patrick Diaz, Family Court Manager, Roxanne Torres, Drug Court Manager, Edward Diaz, Mental Health Court Manager, Victoria Matsunaga, Chief Probation Officer, Matilde Bermudez Rasa, Budget and Finance Director, John T. Villagomez, who is to my left, Procurement Officer, Christine Aninzo, Chief Marshal, Jason Tarcong, Grants Administrator, Jim Stoll, Systems Administrator Michael Villacruzes, and Acting Human Resources Officer Rebecca Santos, who is here on behalf of Michelle Guerrero, Commonwealth Recorder Kelsey Aldan, General Counsel Hyun Jae Lee, and LRC Executive Director Carmen Borja. The proposal that is centered on our strategic plan highlights several areas of priority, and mainly professional services for indigent defense, jury fees, justices and judges pro tems, and interpreters. Under this category, the judiciary proposes a new account for indigent defense. You heard the bar representative highlight that we are requesting for over $200,000 for this particular account. We humbly ask that you grant a new account under this category so that it is formally recognized through the constitutional provisions that are in place. Our priorities include a request for data systems and courtroom technology. It includes a request for utilities to cover our 4 buildings at our different locations on all 3 islands. It includes travel for docket items and case settings required for inter-island travel. It also requests for coverage for cleaning services. As you saw in some of our slides, we entertain 52,000 people entering our courthouses, and this creates safety issues when we come to the cleanliness and availability of our courthouses. We also the request covers our full-time employee positions for our very, very hardworking staff and for the new FTEs that we are seeking. Please help us, and thank you. Thank you so much.
Thank you, Sonia. And I guess before I open it up to the members, the first and foremost, obviously the 2 branches don't control the fund, so whatever is handed to us is what we have, and then whatever is short is our fault. So that is the stress we get. Um, and I want to make that clear because a lot of time our community blames this body for the proposal the administration sends to us, and I want to make that clear that we're in support actually of the court submission. However, the amount that's given to us is, the administration is asking both branches for additional 10% cut, so that makes it even more harder for us to move funds around, and the fact that the vacancies were automatically taken away makes it even harder for this body to find the funds and address. My question now is the allotments. Are they current with the this fiscal year, Ms. Camacho?
Yes, they are.
So, and I believe the administration. I mean, we disagree with the administration taking out all others, pretty much tying our hands each agency. So we have a lot of questions for the administration as to how they're going to handle every agency, and how they would expend their all others this fiscal year. But it's very hard, and we feel, and we're very happy that you guys are spending within your fiscal your budget, um, but also your priorities. I mean, how do you set your goals and how do you reach them if there is no funds for any improvement? Um, and how does the court handle that, given the limited resources right now? How does the goals and objective, I guess, be reached?
If I understand your question correctly, Mr. Chair, how will the court be able to survive if there's zero funding for others, or we don't
Correct.
get the funding that we're requesting? Well, right now it's zero funding for others, and we hate to even consider the thought of closing some of the services of the judiciary, or the thought of closing one, two of our courthouses. Again, that's not in line with goal one of our strategic plan, access to justice. Uh, do we have people come up here to Saipan to, have their cases heard? Or I guess we can take a look at hybrid hearings. What about mental health court, drug court, and the treatment and other treatment courts? You've heard the plea of our judges here. There's a serious case of drug abuse on the island, and I don't know. That's going to be an impossible task. Do we just delete that from goal one, uh, knowing that there is that prevalence of an illness here on island? Do we delete some of the staff from the clerk's office, or remove some of our marshals? We have less than 10 marshals for the judicial system. So that is something that we have to talk about in the coming weeks and months. What is the revised plan? But this is totally unheard of in the history of the 35 years of the history of the judiciary, to have zero funding for others. I guess we have to come back to the other two branches to see how we can work things out. Once you make your decision, once the legislative and the executive branch make their decision as to the ultimate funding for the judiciary.
Thank you. And okay, so we'll continue to the. I believe we have the provision on this current fiscal year with regards to revolving fund. Has the judicial branch dipped into its revolving funds?
We have what is called the justice system funding, and that is, of course, a statutory provision that allowed the judiciary to make a loan application with the USDA. But since the passage of that provision, USDA has changed its position, and they required us to go to a financial institution first before we ultimately avail of their funding. So that revolving fund, there's a balance there, and but last year's budget act allowed the judiciary to use part of that for office supplies and communications. So at the advice, after a meeting with the Secretary of Finance, we have committed, or we have turned over some requests to use that funding for our technology projects. The other revolving fund that you may have heard is, of course, probation and drug court. But I would like John or Son to answer as to the specifics of that. We have the balance of those funding. Oh, they're up on the screen. With respect to probation service fee, there's a balance of 28,000. But of course, probation uses that funding for its training and for supplies for its offices, and also some of the probationers may need assistance from time to time. So we're not talking about millions. It's 28,000 as of last month. Okay, I believe there are 2 or 3 other revolving funds.
Okay. Yeah, we did see that.
In response to your question, yes, we have used some of the revolving funds. We have not tapped most of it. For this fiscal year, we were fortunate to work out an agreement with the governor. Allowed us to tap our ARPA funds to continue to use those. But as we go into fiscal year 2025, as we all know, ARPA will not be. There's a time requirement on that. And so that's why you see our budget request stated the way it is. We would like to ask that if the challenges in the budget really, really restrict numbers for us, to please continue to allow our FTE numbers to remain the same, to not delete those FTE numbers. Because as we go through these federal grants and additional funding throughout the year, our hope is that the economy picks up and there becomes a supplemental somehow, some way, and we'd like to maintain our FTE numbers for that purpose. The second request is that you maintain that clause in there to allow us to continue to be able to tap these funds as we move forward. But the judicial building fund, the revolving account, that is specific by law to that USDA loan, which is still in the tunnel. And so we're very careful about how and when we do tap those funds.
That fund, that's 5720, there was funds that was taken out. Is that from the judicial? Was that from you or?
5720, is that the Justice Center Fund?
The judicial building fund.
Yes, the Chief Justice is the expenditure on that account. And my understanding, based on our discussions with the SOF, is that we are authorized to use that for communications. And so we have been using that to pay a portion of our communications with.
Okay, because it was a large sum that was removed from that. There was a negative balance. Judicial building fund. Okay.
The Justice Center Fund, there was a withdrawal?
Yes. Well, because it's negative right now.
It's a journal voucher.
I
John
can
will
speak to
explain.
that.
Okay.
So they transferred the journal vouchers from JDE to Munis, and I believe that journal vouchers from JDE, and I'm still working with the Department of Finance to figure out what exactly happened. But the Judicial Building Fund was actually paid off in April, I believe 2021 or 2022. So we haven't been withdrawing from that fund since
Right.
then. Yeah.
So it's the amount is still in the
It
air.
it should be whatever we received from when we paid off on to date. So that fund status still needs to be adjusted and worked on.
So it's being worked. They're working on transferring the funds to judicial branch?
So there was a journal voucher that was made on um, JDE, the old accounting system, and we're still trying to figure out what was that voucher made from or who made that. But as of um, the time we paid off the judicial building fund till now, we haven't been withdrawing from that fund.
Okay, so it's not you guys then?
No.
Okay.
No, we are not responsible for that voucher. We
Okay.
are also not sure what what they proclaim the final fund status to be.
All right.
And so we have an idea how much we're collecting and how much that account should have. And so we are in discussions between when that voucher occurred and was it as a result of the transfer from JDE to Munis? And if it was not, and if it was a cost that's allocated to that account, why and where did it come from? Because this statute is specific
Right.
as to that account.
Thank you for that clarification. So the USDA loan is off the table as of this today.
No, it's still there. The new requirement from the federal officials out of DC routed us by way of commercial banks, and that's where we were. The loan is not intended exclusively for the judiciary. It's for the judiciary buildings plus the Justice Center, which includes allocations for the AG's office and the public defender down in the Susupi area. And so if we are to switch gears, that has to be a CNMI-wide discussion. And so to our knowledge, it hasn't shifted.
Okay.
It's still in place and it's still there.
Okay. Sure.
Thank you, Mr. Chairman, and to the judicial, thank you guys, CJ, PJ, justices, judges, and to your team for joining us this morning. Just a follow-up question on the judicial building fund. What was the average collection since the inception back in, I think it was the 9th legislature, or what's the average?
It has gone down. It used to be over $1 million. But the most recent numbers that we have is it's at 80-some thousand. It used to be really high because the court used to collect not just the judicial building fund, but our revenues in totality included those for the executive branch. Now that there's a cashier station over at DPS, most of what we collect is for this account. And at our last review, we're averaging about $800,000, $830,000.
Last as in me 2021 or last as in
2023.
24?
2023.
So 800K.
The numbers are on the screen.
So if that should be like $1.6 million. 2023 and 2022, right? Since the payout, the account was paid off in 2021?
Yes.
Or that loan with the retirement fund, right?
Yes, but I do not want to state that those are the actual numbers. Those are estimates.
Yeah.
Yeah.
But I think with all the vehicles that came in from Japan, those numbers should have increased in the last fiscal year.
They have actually decreased because there's a decrease when we saw the shift in population and as the immigration issues started to take effect, we're seeing less people come in. And if you'll see in our traffic filing statistics, it's lowered. And so as a result of that, collections are lowered.
Okay, since the creation of the Judicial Building Fund back in the 90s, how much was the total collections before the payoff in 2021?
I don't have that number. That is a number that the Secretary of Finance has oversight with, but we can provide that to you based on our records.
It's okay. We'll get it from them. I think we have them
Yes.
tomorrow morning, so we'll ask them.
Well, I think
regarding
that's
that.
I think that's the question also because of this JV, because of
Yeah.
the journal voucher. We need to find out what their numbers were and match them against what our revenue has been for those years since the loan was paid off.
Yeah, I think that's important to have because that's a current revolving account that the judicial branch should be able to access.
Well, and the USDA tracks those numbers as well, because in the contemplation for whether or not this loan will finally be serviced or packaged, our payment plan is contingent on what those collections are.
And I know that's been going on for several years, right? The USDA loan,
Yes.
and now they're trying to switch that, or at least tell you guys that you should go to a commercial bank, and that would come back this way and be considered like a public debt.
Yes. Initially, the loan was going to be direct
Yes.
with USDA, and then the administration changed, and their policy was to go through commercial banking. And so that's where the discussions occurred between us and the executive branch.
This executive branch.
Previous executive branch and into this particular one. But we have not had extensive discussions since the governor at the onset of this year said, hold off, we need to take a look at what our revenues are and what the collections look like. And we haven't gone back to that discussion.
And USDA, obviously they'll change their rules and their regulations throughout the process. I know that this would start out like a $10 million loan back in, 2014, 2015.
No, this was more recent than that, when the legislation was initially passed.
Okay.
Yeah. And so I think you may be thinking about the original loan, which was through the retirement fund. And then we had a balance on that loan, which went into foreclosure and was before the district court. And so through assistance with Judge Kim Tenorio, who's our federal grants chair, we engaged in discussions with the USDA to see how we can make good on paying off on that loan. And that's when those discussions occurred in 2021. And then we came before this committee with the USDA officials to discuss what the terms of the loan would be and what it would cover. We have not rescinded that loan request, and it is still on the table.
Okay. We'll get more to that with the SOF. Should we need to introduce another type of legislation to allow this process to happen moving forward? And I think I have further questions, but I'll use my time for now, Mr. Chairman. Thank you.
Thank you, Vice Chair. I'll open up the floor to the members. You recognize the chair for JGO. I'm sure she has many questions.
Thank you, Chairman. I think my first question is a follow-up to the Justice Center Fund or the revolving fund. So Public Law 725 says that a termination of Section 3409 says termination of the Judicial Building Fund. Did you get any certification from the Director of Finance? That the entire amount of the loan has been paid? Not yet. So technically it's still there. So is that why you're?
We do have a certification from the previous Secretary of Finance that the Justice Center Fund has been initiated and that the Chief Justice is the expenditure authority.
Okay, but that loan has been paid off completely in April of 2021.
Under the previous statute, yes.
Okay, and then when it was paid off, you got a certification from the Director of Finance or Secretary of Finance?
Not to my knowledge.
No? Okay.
But we do have a letter from, we have an acknowledgement of our letter to the Secretary of Finance, where he acknowledged and he signed off
That,
on the letter that because of this statute, the Justice Center Fund exists for this purpose.
okay, but
Yeah.
that initial loan was already paid off initially, right? The 15 million.
Yes.
Okay, and then upon that, because it was paid, you sent a letter to, or the Judiciary sent a letter to the Secretary of Finance acknowledging that this particular statute is here. In the letter, did it say anything that it's been satisfied, the loan, and all the expenses and the debt has been paid?
We didn't send a letter as to the loan because the loan was under the oversight of the Secretary of Finance
Correct.
and was involved in litigation documents under a settlement agreement
Mhm.
with the U.S. District Court.
Mhm.
Our letter was to reaffirm the intention of the Justice Center Fund
Mhm.
and how that started and how it proceeds moving forward, and where the fund status reports will be overseen by us.
Okay, so I think, and the
And
reason
we-
why I'm asking is because in that public law that's cited in Title I, Division 3, it says that upon the termination of this particular fund, the Director of Finance shall certify and discharge that there has been a payment in full. And you state that there has been a payment in full in April of 2021. So my question, I guess, would go back to the Secretary of Finance, either before or now, to recertify that and request, has that been done? Because then that will allow the money of 15% to go to the Justice revolving account for the maintenance needs of the Judiciary's facilities, and the remaining 85% of that will go into the general fund for appropriation.
You are correct in that she may have issued a certification letter. We cannot answer as to that because there was a case before the district court, but she may have provided that certification
All
on
right.
behalf of the CNMI to the court, the other court.
Okay, so we'll just follow up on that. Thank you, Ms. Owen. I
Yes,
appreciate it.
thank you too.
So one of the things that you're asking for is this new business unit, the Indigent Fund of 200,000. Is that correct?
Yes.
Okay. And in the Indigent Fund, it is supposed to be used for, I guess, to increase your access to justice for indigent families or individuals who qualify under that particular bracket.
Yes, it's mainly to be used for court-appointed counsel
Uh-huh.
and specialized investigations for criminal cases. And as Attorney San Nicolas indicated, in civil cases, when there is an issue of incarceration and they cannot afford an attorney for such purpose, then we appoint for that. Currently, we have been funding these costs through ARPA, but ARPA is depleted and is running out quickly. And
Okay.
this is a big cost that continues to eat up the judiciary's general all others budget, when really it should be carried as a CNMI wide item. We are probably the only jurisdiction in the US flagship that doesn't formally recognize this on a separate account or in a separate form of or an agency action that specifically budgets this item. It is constitutionally mandated,
Right.
and it's a provision that we feel should be formalized, if not in another form, then definitely in the budget process. And so that's why we're seeking the
Well,
specific account.
Okay, and that's a right that they're afforded. I should know that because we have a bill that's sitting up at the Senate that, the public defenders and all the other attorneys are going back and forth as to what is, that stuff. But I'm not going to get into that. My next question is in terms of access to justice, and that was mentioned earlier. Micronesian Legal Services does not take any criminal cases, but if the case was, to save the family, assuming that the individual was a victim of violence, then maybe Micronesian Legal Services can kick in, correct?
They do take on civil cases. We see them covering cases on paternity for child support and also for cases that you just described,
Okay.
as well as probate. But I am not sure what their funding levels are and where it comes from.
Okay, I know that they get a lot of federal funding through Legal Services Corporation, which is federally mandated. It's unfortunate that it is a grant based on population, so it's very competitive. So I understand the need for more supports. One of the things that stuck out to me was that there are about 200, almost 300 private attorneys in the CNMI. That's a lot of attorneys for 50,000 people. And what they charge, and maybe this is something we should bring up with the Bar Association, what they charge is an annual fee of $250, an earmarked fee of $25 to Micronesian Legal Service. So there's a big disparity when you're talking about taking care of indigent clients who may need attorney representation. And I know that the Bar Association also sits into the Justice, what is this? Justice.
The Judicial Council.
That one. And they sit as a non-voting member. So maybe one of the things that the court should consider is having a conversation with the CNMI Bar Association to lift up those fees for private attorneys, because for 300 attorneys and only $25 is earmarked for MLSC, whose sole purpose is to provide for indigent representation for clients of that such in that category. And we have people, nonprofit like Micronesian Legal Services, coming up to the SNILD committee asking for additional funds to help support the court and support the population that need legal representation. So maybe lifting up those fees would be one. And then, access to justice is just as important. And you're talking about the e-courts and one of the goals that you guys have, but also improving legal aid access is just as important. Pro bono services are just as important. Do you know the number of how many pro bono cases you guys take? Is that a data that you guys collect?
We track only
Proceed.
our court-appointed counsel listings, and we also track the cost for those services that we offer. The bar may have their numbers. I do know that what you see on the Bar Association roster listing is the active members listing and the inactive members listing. Not all of them are actually practicing. And so when we talk about those numbers, it would be best to approach them for how many truly are active in the CNMI.
There's about 160 some that's active total, which is inactive, active, and temporary.
And then the
which is-
active has on island and off island.
Correct.
Yeah.
Yeah. Okay. Well,
Thank
and
you, though,
again,
for-
that's something that maybe since they sit on your council, because I know I've asked to sit on the council and I've been denied 3 times. So if that's something that you guys can probably bring up to the Bar Association, is possibly lifting that up. I mean, we know that there are private individuals who are indigent that come up here and ask for legal representation, but they cannot afford the fees for private representation. Some attorneys are charging over $300 an hour, but yet their bar fees, annual membership fee is $250 for the amount of money. This is a business. This is not representation if you look at it really from my perspective.
Thank you for that recommendation. We will take it back to the bar.
Thank you, Ms. Sonia.
Okay.
Yeah, Congresswoman, if I may add, we've had a difficult time also getting attorneys to be involved with indigent representation for the obvious reason of economics. If you mentioned that they're earning $200, $300 an hour, the court doesn't pay much for in these criminal cases, so they're reluctant to get appointed. So we find that a challenge. To the point where I think some of the judges have recommended that we assign attorneys who are working in the autonomous agencies to take these criminal cases. So even with that, this is our pro bono, we're paying them substandard earnings compared to their $200 or $300.
Is it still $75 an hour?
Yeah.
Okay,
In
so
addition to the indigent, I just want to point out that we use the funding for interpreters. We're seeing a continued increase in interpreter services. We really improved our LAP program, limited English access program. We're also using it for psychological evaluations. So not only attorneys, but all of those auxiliary services are part of the indigent funding request.
okay, and in your interpreters, does that include access for individuals who are deaf and hard of hearing? Does that include American Sign Language?
Yes.
Yes. In fact, we've really extended that, and Judge KT, using federal funding, we're getting some devices, assistive listening devices. I think we have 2 or 3 devices that we will soon. We're finding that we have an aging bar and also an aging bench. So we need assistive listening devices.
That works. Access to justice is all around, including the judges. The other question I had is, so in terms of the Supreme Court has the authority or some powers to waive the bar exam. And I know that there's a law also that changed that from 4 years to, I believe, 8 years now. And maybe one of the things that you should maybe consider is if this indigent category is hard to maintain, 200,000 really is not going to be enough, to be honest. That's a very minimal amount of money. When you're looking at a population of almost half that are indigent. So there's still a disparity there. But maybe one of the things that you can consider is, having them take on these pro bono cases, because if they're not taking the CNMI bar, then how do they know about the people, right? And the way they behave and all of these things. I didn't take the bar, so I'm not sure what's on the bar. But when we're recruiting, one of the things that we're finding out is that when we're recruiting from the mainland, attorneys who have just graduated from law school that want to come here for the minimal amount of salary that we offer, is that they don't know our culture and our custom. And maybe one of the things we should consider is having them take on those cases pro bono so they have a real interaction of the needs and the behaviors of the people. If we're talking about indigent, because that's almost half of our population. So that's something that, maybe I would hope you could consider, because moving forward, it's access to justice for a lot of us means access to an attorney. And we have all these wonderful courts that are going on, but there's other problems too within our community, like probate. That's extensive. It's expensive to have that, but the rule says you cannot go into a probate matter without an attorney. So even if somebody wanted to go in pro se and fight for their land, they can't do it. It requires an attorney, which is expensive. So please, if you can consider that, I would be very appreciative.
We are open to that, Congresswoman. Thank you for that suggestion.
Okay. Another thing that I wanted to mention, can I continue? Okay. On legislative bills, I know that we had requested, at least the JGO had requested, and this is important because it also comes down to budget when we're asking the legislative body, the courts. It does say that you may, in your personal capacity, comment on certain bills that are asked of you to comment on. If you can, moving forward, reflect internally, and if you could, it would be really important for us, especially in this committee, to hear from you what you think about certain bills on a personal capacity. Because while you're given the autonomy to have this leverage of interpreting the law, we also would like to have some access to, how you feel about a certain bill. Because you may comment, which is up to you if you'd like to or not. No one's saying that you should, but at least. And then one of the pressing things that come out in the budget, and I didn't see this, but when cases are presented and judges recuse, where does that come out of? What budget line item is paying for these outside services to occur?
That would be the professional services.
Okay.
We have a professional services request under the.
Is it justice and judges?
No, it's under the administration account. And it's part of that category along with other professional service contracts that we have. But that goes to pay for the pro tems that come in. They're called pro tem justices or pro tem judges.
Okay.
Yeah.
So that's 445,000.
Well, that number includes our indigent costs as well. So it's not just, the 400,000 is not just for the pro tem services,
Mhm.
but for other things, the interpreters, yeah.
Okay. So how much in this line item for professional service for fiscal year 2025 did you request for off-island pro temp expenses? Since it's kind of everything together.
Together, I would say approximately $5,000. But as we see cases coming in, we can hit up to 10,000.
If I may add, Congresswoman, today there is a pro tem judge from Guam. She arrived this morning, but we don't pay them hourly. We pay for their travel and probably a hotel room for the night because there's no return flight this afternoon. Okay. And we reciprocate too. I've been sitting in the Guam Supreme Court for over 24 years, assisting them. And they come to assist us. CJ goes to Guam occasionally and Palau. So there's this reciprocity amongst the Micronesian jurisdictions. I don't get paid when I go to Guam. They just pay for my airfare. I think that right now, Guam Judiciary has been doing a lot for us. So they don't get paid hourly or $200 an hour. We just pay for their breakfast and lunch. And they spend, for a given case, I mean, I myself I have a hearing in Guam this Thursday, and I spend hours and hours, and so do they when they handle our cases. They spend hours and hours prepping them. They use their law clerks. We don't pay their law clerks, and they use our law clerks too. So it's just a minuscule amount that we pay for their important services. And why do we need them here as pro tem? Because the Constitution allows us. There's a statutory provision that if we have reason that forces us to recuse ourselves when there's a conflict. We don't know. Sometimes we don't know what that conflict is, depending on the judge. So, you folks can change that provision to allow us to accept cases even despite conflicts. But this is justice. And of course, we're concerned about the parties and how they perceive their cases and the judges, how they're handled in court. So they're not getting paid, basically.
Okay. And the reason why I asked that is because there has been, at least for fiscal year 2024, there's been a substantial amount of cases in which the judges have recused themselves. And we also believe, at least the Commonwealth believes, that access to justice also includes access to, speedy trial in regards to cases that are highly publicized. And our people, at least the Commonwealth, the general population outside of your peers, would like to see some kind of activity happening. And when we are presented a retention on the ballot, we go there and we retain our judges because we believe in them and we know that they are more than capable of hearing cases regardless. Yes. So knowing that, that's something we would, at least I will revisit. I think that there should be a total number of cases that you can recuse. One should recuse themselves on, but I don't think it's fair to the general public that there is this great power for the judges to just recuse cases and not even acknowledge as to why they're recusing themselves. And then I'm just looking at your fees, and there is a disciplinary, portion there, disciplinary report that you guys charge. I think is that for the judges or is that for attorneys?
I don't understand your question. There's a disciplinary report?
Yes, that you have on your fee schedule. Is that for the?
Oh, for the attorneys and judges.
Okay.
Yes.
So I think, in terms of that, right, I don't see why you guys should charge that. I think that should be open to the general public. I think report cards for how the judges perform should be there. But again, that's discretionary because you guys have your own rules that you are guided by, and I can respect that. So if you could just take a look at that. Maybe consider me to be part of your council. I would love that.
Yes, we received that letter, I believe, about 2 years ago. But Congresswoman, I really appreciate your focusing, zeroing in on goal one, which is access to justice. We fully agree with you on that. And we're also goal two, which is the timely resolution of cases. If you look at our strategic plan, this case management system that we will turn on in a couple of months, we will be tracking all the each case that gets filed. We will be tracking its progress during the time in the Superior Court and Supreme Court, and each judge and justice will be accountable for their cases. We will know how long a judge or a justice will handle, for instance, a particular motion, since when that motion is filed, when the hearing at that motion is held, and when the decision on that motion is issued. So that's why we have this case management, and all of these will be available to the public in our reports.
Okay.
So we are very mindful of the efficiency, and I think we're making great strides in that direction. So that is the interplay of goal one and goal two. But thank you for pointing that out this morning.
Thank you, Judge. And I'm almost done, if I can. One of the things that we have been approached with is not everybody can go to court, but technology has allowed the courts to be at our phone when we just depending on who we follow on our social media. One of the things that we've been asked to do is consider actually putting cameras in the court so that the people could have access to you and to watch and to hear how you interpret, how you manage your court. How do you feel about that? And I'm sure it's going to cost money, but
yeah.
I'm just asking.
Yes, well, we've considered that. And of course, one of our technology projects is the court technology, the courtroom technology. And we propose that 100,000 to 125,000 be allotted for each courtroom for all the technology and the camera. That has problems also when there's a jury trial, and how do you shift this camera so that you avoid the jury? And what about if a minor testifies? Those are the issues that we're looking at. So we're not blind to those developments. We see them in other courts, and they're successful. And I hope that we can perhaps do them in phases.
Okay.
But we have hybrid courts in the Supreme Court. We have our hearings on YouTube so that the students in Tinian and Rhoda and anywhere from around the world can tune into the Supreme Court hearings. We have to take a look at the Superior Court.
Yes, please. And if you can consider that. I mean, a lot of it is crime driven. But with these special courts now, it changes the dynamics, right? And again, that would be your authority to design those rules on how each judge and attorneys will perform in your courtrooms. But I think for now, Rep. Atal, I'll yield my time. I have some other questions, but I want to yield my time and give everybody else a chance. Thank you. I yield. Thank you, Judge.
Thank you, Rep. Flores, and thank you, Justice. Any further from the floor? Rep. JP Sablan, and then Rep. Manny Castro, please.
Thank you, Vice, and thank you, Chief Justice and Justices, and PJ and Associate Justices for coming here, and your team. There have been a lot of talks about lifting up the traffic fees, such as the speeding fees and all that. And I know that most of these fees right now are going to the Justice Center Fund, right? And there are talks of lifting up these fees and perhaps just having what's collected by the judicial branch remain, and any increase would go to the prospective agencies such as DPS and DPW. And that is something that I actually am looking forward to work with all the agencies, including the judicial branch, and perhaps maybe the funding that remains could assist you guys with the needs that you are requesting this August body to find the fundings for. Is that something that you guys are open to? Anyone can answer.
Yes. We are open to any discussions regarding revenue generation and anything that impacts the justice system. We will welcome if we are welcome.
Okay.
And I understand too that the presiding judge who sits as chair of the TRCC committee, they too are looking through that avenue where these traffic fees are and how to address them in such a way where it's brought forward. The fees that are in place are from many, many years ago,
Yes.
before federal legislation even,
Absolutely.
and so they do need to be brought forward.
Yes.
And also consider the administrative costs of administering the safety of our roads.
Absolutely.
And so they're looking at that. Yeah.
And that's the reason why I asked, because with those fees right now, I don't think it serves for deterrence already. Those fees are just, for my opinion, are just slapping the wrist, and we need to lift up these fees so that it serves the purpose. And maybe a $25, a $50 doesn't hurt the pocket of our citizen right now, but maybe $100 or $150 would probably wake them up, right, and stop running those red lights and whatnot. But are there any of your rules that that needs to be changed if we're going to lift this fees up?
That question is for Justice Enos. He chairs our traffic rules, and also for PJ Naraha.
The traffic rules have been adopted, already changed, and thanks to the legislature for approving it. Now, the only other thing that needs to be done as far as e-citation is concerned is the training aspect of it on the DPS end and the full integration into e-courts. That's the only thing that remains. The rules are in place.
So the rules are in place, but the reason when I asked is that if we're gonna have these fees remain in the judiciary branch, we want to try to make it as flexible as we can, no, so that you can utilize these funds for whatever purpose. So I look forward to working with some of you guys on this. Thank you, Vice, and you.
Thank you, Rep. Sablan. So I guess we need a letter forthcoming from the judicial branch in support of legislation to repeal. And this is good. We're going to have to do it this way, to repeal the judicial fund law, because the judicial fund law is pretty clear that once we exhaust or once the loan is paid, it kind of ceases. So in order, we'll repeal and reenact to change the fees at the same time to remain, or whatever. If it's 150 and you're taking $25, maybe we can bump that up to $50, and then the $100 gets spread out to the other entities. And a support letter from the judicial branch would be greatly appreciated by this body, so that there's two branches that in support and the administration signs off on it. At least the people of the Commonwealth would see that all three branches support that type of legislation. So, Rep. Castro, please.
Yeah, I second that motion also. Without the evidence, you have no case. So forensics and everyone else involved, they need some funding for their technology and personnel as well. I actually just wanted to comment on the Judiciary's forward-thinking joint venture with NMTI and having the, I believe was it the probationers or take classes rather than just community service work. I think that that really stretches their, it really stretches the goal to end recidivism. And, being an enrollment manager, enrollment director for many years, there's so many of our youth out there that they just took the wrong path, and given proper guidance and support and to help them see the potential that they can reach. So programs like these, I really think will make a strong impact to the future of our people. And I just really wanted to stress my great appreciation to the judiciary and the folks at NMTI. I also hope that the judiciary looks for other training providers as well. Maybe the Western Pacific Maritime Academy. They've been doing pretty well in getting more merchant marines out there. And the pay is really well. And we have so many pre-positioned ships right in our lagoon. So that's other opportunities. NMTI and any other career that they can get into. Thank you so much.
Thank you, Rep. Castro. Response from the judicial?
Yes, we look forward to that. And the chief of probation is here. She is really working hard to put that program together. And we look forward to doing that.
Thank you, PJ. Any further from the Rep. Joe Flores, please?
Just one question. Can you go maybe go through the process just in this regarding e-ticketing, the e-citation? Like you said, you're going to implement the process of taking into e-citation. How
Correct.
is it going to go? Like the police officer, how's the process when violations been stopped and how did it go?
There
about?
is a current contract between DPS and Let's Light. The Let's Light as the provider of this equipment. So an officer out there, well, first of all, the police vehicle is equipped with Let's Light device. And I'm told, I haven't seen this equipment, but I am told that it is a portable device that you can just bring out with you from inside the vehicle. You stop a violator, you go up there, you have your device with you, introduce yourself, what the violation would be, and this officer would just be punching the put on menus, what the violation, and then after getting all the information, from the violator, with a press of a button, that information goes directly to the court. One goes to the AG's office, one to DPS, and maybe some other agency.
So this process has been going on since back in 2021, right?
The process? No. We've announced it in 2021 that this is what we want to do.
Okay. Because I remember way back in DPS actually came out with the traffic section. They got the instrument that like free citation. The vehicles were already installed in their their vehicle, but the system with the TRCC program and from there on you get working, it never materialized.
Oh, I stand corrected, and I think Presiding Judge Raha can explain on that.
So we did hire Let's Slide to manage the e-citation before the e-courts come into place. There were many difficulties we received from the contractors from Let's Slide. Basically, those portables, those computers, they had some difficulty being placed into the vehicle. And then we had problems with how a vehicle would pass through the Judiciary building, and that it should automatically file that system into the court system. There were difficulties in how that technology transferred those e-citation, and that's where the delay is. But with the e-court, I think the computer system is much better, much effective.
Congressman, if I may add, so, the technology of 5 years ago is very different from what it is to now. So there's internet problems, but now we have this e-citation, and the judiciary has hired a company that will provide the interface between e-citation and e-court. So these are all technical terms, but we're getting actually not just two companies, but three with our e-file and serve. So the judiciary has provided the technology and the funding for e-court case management, e-filing, and then the e-citation. But these, when they talk about Ledgelight, you're talking about how DPS would upload it to their system and then they transfer it instantaneously to our e-citation, to e-court, and then file and serve. So that's the technology we have now. You're talking about 4 or 5 years ago when DPS had its own portables. I think they purchased 7, but those are obsolete now. Yeah, they're obsolete.
Yeah, the reason why I asked to right now is this is the process every year, every month, every couple of months, the technology changes. And we're going to keep coming up with this planning. And by the time we plan and we're ready to go on, the system's already obsolete. So what we try to say is if we can always try to speed up the process as much as possible, what can we do and what funding? Because we can keep waiting and waiting. The e-citation is useful and it's much easier for the software because everything's direct. And also maybe keep in mind, maybe take a look at that regarding motor vehicle to our driver's license system, how to incorporate the real ID, because the problem with the motor vehicle and officers, how can we, with this e-system, e-citation, how can we detect the person that the officer pull over? Is there an outstanding citation violation that the system will give him a red light? Because nowadays we can't even determine if the person has an outstanding DUI, outstanding arrest. We have to manually check. But hopefully this system will incorporate that will make the easier process of the judicial system and the officer. Okay.
Yeah. I venture to guess that the issue is the budget. How do we populate that barcode in the back of our driver's license? Do we even have real ID? I don't know. I think it's budgeting. Do they have the funding to pay the vendors out there and the annual license fees or subscriptions? So, if there's funding, then we can use those barcodes. I hope that they do populate the barcodes in time.
Thank you, Rev Flores. Before I recognize other members, may I just ask how much is left over under ARPA for the judicial branch?
The judiciary has used about 67% of its $14 million allocated. So we have about close to $4 million left. We have plans for those $4 million. Of course, we have the ARPA data center and assembly hall, which will house our millions of investment in technology. So yeah, we still have 33% left.
How about in federal grants? How much does the judicial branch receive?
For federal grants, we are happy to report that Congressman Kilili assisted the judiciary in recent years. We have, in this fiscal year 2024, the federal funding for courthouse security through Congressman Kilili. We received $850,000. We also have funding for a study for Veterans Court. That's about $303,000, I believe. And there are a couple of others. Drug court. Oh, they're on this. We have, thank you, Mavi and Tracy, for doing this. You make answering the questions easier.
Okay.
So there it is, Vice.
I just want to point out that some of these are multi-year grant duration. So the total amount is not available
Yeah,
to us.
that was actually
Yeah.
the question is they're your fixed annual amount on grants.
Yes, and then they're scope specific. So none of these are all for action items. They're not for FTEs and are very restrictive. Yeah.
Okay. I'm asking this because we got to go back to the judicial fund building account, and we really need your help to get this, at least from your side, what the true number is, or what should the true number be for 21 moving forward, right? Because those monies were never really remitted to you guys. It's on a case-by-case basis of asking finance to release a certain amount of money for you guys to utilize for technology.
Vice, if I may just ask, before you try to extract funding from the Justice Center Fund. Please consider that the judiciary needs those fundings to maintain its buildings. For instance, right now, we have elevators that are not operating. If you go down to our Sallyport, there are 2 or 3 elevators that will transport detainees to the courtrooms. They're not working. We have to bring the detainees in through the front doors, and they mingle with other patrons. We bring them up along the staircase or the one of 2 functioning elevators in the building. So how much is that elevator in the detention center? That's about $200,000 each. Last year, you asked us, this committee asked us to look at other funding. Well, we did. We went to USDA, and they provided about $225,000 for the service elevator in the back, where where staff is able to move up files to the second floor and other cargo. So we have other projects in the hundreds of thousands of dollars. So please, we'd like to have a chance to meet with you or the committee before you draft some proposed legislation to take funding out of the judiciary.
Intent is not to touch the funding for the judicial. The intent is to be accurate in this appropriation, because if the administration or the finance is limiting the judicial branch from utilizing those funds on a case-by-case basis, because it's in a special account, we might have to appropriate it, pull it out of that special account and appropriate directly to the judicial branch on a supplemental budget within 2025. But the only issue with that is once we pull it out of that special account and appropriate it, it opens it up to the 25% to PSS. So 25% of that amount of money will directly go to PSS. The remainder would go to the judicial. I just don't want to have them tie your hands. And then if we do appropriate those funds, we don't want to just limit it to its intent for the building, but allow the judicial branch to be flexible in utilizing the funds to address its needs, not just the building needs.
Well, and the original intent of the Justice Center funds was not just exclusively for the judiciary. It was to provide for the projects for the Attorney General's office and the PD down at the Civic Center. And so the discussion has to include that, whether this loan will be pursued further, and what is the adaptability to the repayment plan.
Not the loan. I'm talking about the liquid cash that's been being collected and being held at finance. That's the one. If they're not allowing the judicial branch to utilize those funds as FY24 states that you can be flexible with your special accounts, and they're limiting the judicial branch from utilizing it, we might as well take the money, appropriate to the judicial branch, but with the understanding from the judicial branch that 25% of those monies becomes general appropriations and would have to be remitted to PSS.
Yes, we are amenable to that. I think you're asking for an expansion of the authority under 3405. Right?
Sure.
Yes,
Sure. At the
we're
very
open to
least, for
that.
for a supplemental portion for 2025.
Yes.
But
Yeah.
it also opens it up to the 25% to be
Yes.
submitted to PSS.
Yes, so you have that provision in the current budget law. Also, if we can expand that language to not just limit it to office supplies and communications, but to expand that language.
Sure. But my only concern is it's obviously finance is kind of limiting the judicial branch to the access of those monies.
No, they're
No?
not. They are cognizant that the expenditure authority is the Chief Justice, but also they are the authority now that allows us to tap it is in the current budget bill,
Yes.
which expires September 30. And so they're aware of that, and they've been operating under under that authority. But the bigger question is as to the original intent of the fund, which was for us to seek that loan. And so
Sure.
that's why we engage in discussions with them. But this current Secretary of Finance has worked with us in all of our calculations and what the numbers are. I think what we're just waiting on is what that JV represented and what is the true fund status.
Okay.
Yeah.
Okay. If there's no issues, then we'll leave it as is. Just maintain the current language of the FY24 with more flexibility.
Yes.
Correct.
And maybe some consideration for indigent defense work.
Sure. Well, it'll open it up once we remove the materials and all of that kind of stuff in there. And with the indigent account defense or indigent defense account, I know that the court's requesting for that as a new line item, correct?
Yes.
And currently those funds are being used up under the administrative account, correct?
We've been covering it under the administrative account, but because we were zero funded for the most part, we have been using ARPA funds to cover some of these costs, which are now depleted.
Okay.
Yeah.
So at the very least, we need to open the account so that
Yes,
there's
please.
there's an account that's available to have funds submitted into it
Yes.
rather than, so it's specific to its cause.
Yes, please.
Okay.
Yeah.
All right. That sounds good. All right. Thank you. Thank you for your time. For the last round, Rep Flores, please.
Okay, so thank you, Vice Chair, and thank you. That's a lot of information. My next question is, we talk about all of this technology. You have a broken down elevator. In your budget for maintenance, you don't have anything here for maintenance of your building. You have fuel and lubrication, but there's no maintenance for equipment. You have zero for improvements. So where would this money go? I mean, every year you're going to have to be maintaining this equipment. So how are you maintaining that if you don't have a maintenance plan?
Our maintenance plan for this fiscal year have been funded through ARPA.
Okay, so on your general fund, since ARPA is going to be depleted, and it will deplete in December of 2024 or October 1st or September 30th of 2024?
Our encumbrances through ARPA have to occur before December of this
Okay.
year.
All right.
Yeah.
Okay, so there's no maintenance plan.
Our current maintenance plan contracts that are in place for the air conditioning system and for the other bigger systems are on current contracts that were funded by ARPA.
All right.
And two of those contracts run through next year
Okay, so you're okay as far as maintenance.
for some of the equipment. But there's the general maintenance for the vehicles. Those are based on an as-needed basis. So our vehicle fleet and other different items that break down every now and then throughout the building. The other items that we are currently seeking assistance for is our percentage match for the FEMA costs for some of the repairs that need to be done still from prior typhoons.
Okay, how many cars you guys have? Is that including the Marshall, your entire fleet in
Our entire
Judiciary?
fleet.
How many?
It's for all of our vehicles. We have 26.
26. Does that include official? Do the judges have cars?
The bench have
Okay, and that's part of your maintenance.
yes,
Okay, so 26 including them, or that's
26 total for the
Got it.
entire branch.
Okay,
And we are very grateful to the executive branch for giving us
a car. Yeah, I
yeah,
heard.
we had requested in prior budget years for vehicles, but the governor and the lieutenant governor were able to
Yes.
provide
Give
us
you-
some vehicles from
right.
the executive branch fleet.
Yeah.
Yeah.
Yes, thank you to them for giving that to you guys. I know that, everyone has different needs, and when you can get help anywhere, it's always a big help.
Yeah.
Going back to the disposition, this is another revolving fund, disposition of abandoned property. It says here, if property remains unclaimed for 120 days after notice has been given, the administrator shall petition to the Superior Court to request that an order be issued directing the property to be transferred to a Judiciary Legal Services revolving fund. Is this the same as what you're asking now? Because the Judiciary Legal Services revolving fund shall also, number one, pay for indigent legal services, including but not limited to attorney fees, transcriptions costs, translator fees, expert witness fees, investigator fees, and other costs. Is that the same, or is that two different things?
That's different.
Okay.
So that particular legislation came into play when we approached help from the legislature at that time.
Mhm.
We had fiduciary funds that had sat in our accounts for over 20 years. They were from either unclaimed bail monies or items that were left over from other civil cases that remained unclaimed. And so that particular statute allowed for a notification process where we alert through publication, hey, there's these monies that are here with us.
Mhm.
If you think it's yours, come forward and claim it.
Okay.
And if nothing happens within a set number of days,
Mhm.
then it goes before a judge to dispose of
Mhm.
into this account
Mhm.
for payment for indigent.
Okay.
We have made determinations from cases where those funds were abandoned,
Mhm.
and we have paid out for indigent defense and interpreter
Okay.
costs.
All right.
Currently, our balance is, if I'm not mistaken, it's under $200. And so the total funds that were deemed abandoned that have been paid out, you're seeing that figure on the screen.
Okay.
And that's contingent on the activity for the cases, when they're disposed,
Mhm.
and if there are funds from those cases that remain unclaimed.
Okay. And then my last, I don't know if it's my last, but the probation. I notice, I'm looking at your staffing for probation. And a lot of these individuals have been there long time and they're still ungraded, which means they fall under accepted service, which also means that they carry with them an amount of knowledge that might be irreplaceable to some, but I think to the court, it means that they've been trained long enough. They've been there many years. Right now, your average for every probation officer is, you said the ratio was 1 to 60? 1 probation officer to 60 probationers? Is that correct? Earlier?
Yes, the presiding judge testified earlier. But as to
60?
60 to 80.
As to your earlier statement on the status of the FTEs,
Mhm.
the judiciary issued its personnel regulations in 2015,
Mhm.
and we don't have a civil service class system. We currently have 4 that are grandfathered in
Yes.
at the time that regulation took effect, and so
Correct.
all of our staff are
Or
ungraded.
ungraded. Yeah.
Yes.
I was taking a look at who and your
Except
civil
for 4.
service. Yeah.
Yeah.
Have you considered making this switch and at least offering, because there's there's disparity when you look at the commitment that these people have given. And they really don't have, assuming they want to go somewhere, right? That's great. But you have an individual here who's been here for almost 25 years, ungraded. I don't know. I'm just thinking, how can you also, put them in a civil service position and maybe consider that. Right now, people just want to wake up and have a job for the rest of their lives. It's not about how much money anymore. It's about sustainability, right? And to have a job all the time. One of the things that was also brought to my attention, and maybe that's one thing you guys consider, but I know that this court is very strict when it comes to making public appearances in any political engagement or function. But I do see an injustice when it is applied to an employee after 5 o'clock. Because I can tell you, I've also seen many people within your court system who make certain appearances. Have you considered maybe changing that policy and allowing them to participate in civil engagement because it's their right after 5 o'clock?
That is certainly an item that the Supreme Court can take into consideration. As to your first statement, which is a very valid concern, not only for probation, but all of our longstanding employees. They are the backbone of the judiciary. We have 4 sections of law enforcement officers, the marshals. They are expected to take a bullet for participants who come to the courthouse, monitor what happens in the courtrooms. Probate cases now are heating up. So it's not just in criminal cases where you expect to see law enforcement coverage from the front steps of the courthouse to afterwards. in recent years, we've seen activity on the national level against judges.
Mhm.
And so now our concern steeps out into their homes and what
Right.
they do. And so the concern of proper pay
Mhm.
and great pay
Mhm.
is of utmost priority.
Okay.
We are not the judiciary without our staff.
Absolutely.
And so we would love to properly compensate and bring those salaries up to where we think it should go.
Okay.
But given the economic structure and the limitations of our funding,
Mhm.
we have tried to spread that across.
Mhm.
We provided through ARPA and other means those one-shot amounts that allows us under the rules.
Mhm.
But for permanent costs and permanent salaries, what we did was we hired an independent consultant,
Mhm.
Mr. Frank Gibson.
Mhm.
He came in, he took a look at what our human resource practices are, what our forecast would be with the growth that we anticipate based on our strategic plan,
Mhm.
and what the national standards require for us as a U.S. court system. And he has provided a final report, and that is currently before the Judicial Council and the Supreme Court for
Okay.
consideration. But it comes down to funding.
Yeah.
We can provide ample funding and wish for it, but if there's not enough to go around, then we just have to wait until that time comes.
Okay.
In the meantime, we have dedicated officers who cross train
Mhm.
because we are short-staffed in all of our areas.
Mhm.
So the probation officers help the marshals. The drug court compliance officers, who are law enforcement officers, also help
Mhm.
when there's a need to. So there's cross-training,
Mhm.
and there's certainly enough to justify
Mhm.
salary increases.
Yes.
But it's a matter of how do you provide the funding so that it is equal and that it is stable and that it is permanent.
Mhm.
And so I thank you for that, because that's a great show of support for our men and women in badges. And
Yeah.
it's not just probation, it includes all of our law enforcement officers who put their lives at stake and leave their families at all hours of the day and night for probationers, for family court, for mental health court, for court patrons on all three islands.
I think the clerk of courts also is one of the areas where I think there is a disparity. That's your front line, really,
Yes.
in the court system. They
The-
receive everything.
The report that we anticipate adoption on proposes that a starting salary at the judiciary be at $25,000. Our performance benchmarks, when you start with us, you have to know computer software. You have to know certain data systems, because that's just how justice is streamlined across the nation nowadays. And so that's the recommendation, is to start at 25,000. But that also requires that once you start at that level, well, what happens to these people that have been existing in the system? It means we have to bump them up for the number of years that they've been with us, and they have the resources and the remedies for us because of their years of service to us. They would need to be bumped up. But those, in the end, come down to budget figures. How much can we do it so that it's equal and fair and it's merit-based? So it's not just one or two people
Yeah.
getting it, but everybody that's meritorious of it.
Okay.
Congresswoman, if I may just interject, while we're speaking about law enforcement, the judiciary is very proud of two of its employees, one at probation and the other one at the marshal, because they're gold medalists in the micronesian games. Saw what are their names? Ryan Babauta and Dan
Mr.
Joa.
Joab. Yeah. Dan
So
Joab.
we're proud of them,
Congratulations.
and they're not paid
Yeah.
adequately at the judiciary.
You know, I mean, I agree. I think that's one of the things that we have not planned accordingly and appropriately is the pay. But I do believe that at some point, those that are in public service, especially the judiciary and the staff and PSS, everybody across the board should be compensated appropriately. And so many years have passed and we're still at this point. And then my last comment is, really consider how much power does one have over staff when it comes down to exercising their civil, participation. I don't believe that anybody that works in the court should be held to not being able to practice that. Just because there's a political kind of way of doing things here, that doesn't mean, I mean, I know for a fact, and I would believe that your staff knows what boundaries they should and should not take. But to limit their access to participate in civil engagement, I don't think that's appropriate. So please reconsider that, take a look at that, because that is against their right to assemble with whoever they choose to, regardless. But I don't think that they should be held hostage after 5 o'clock if they want to support somebody who they believe is an appropriate public servant to them, and exercise the same moral compass that they do. I don't think anybody should hold anyone hostage when it comes to that. I think after I don't have any more questions, but once this committee comes back to consider what is appropriate, then I will, advocate as such. But thank you, everybody from the court. I appreciate it.
Thank
yield,
you.
Mr. Vice Chair.
Thank you, Rep. Flores. Rep. Benavente, before we close out, because I know that the justices and judges are hungry.
Thank you, Chairman. I'm in Vice. I know I'm the last over here, and Chief Justice and all the other judges that are here and members of the courts. I just got a comment over here, actually. I echo both ladies beside me, Judge Kim Tenorio and Judge, the newly chosen judge, Lilian Tenorio also. I echo with regards to their vision as far as their job's concerned, as far as handling for example, the drug court and stuff like that. I believe also, I was once a member of the Board of Education, and I was involved in a lot of this in the educational system. And I know that there's a program that was introduced here. Unfortunately, I don't know how they took us apart from that program. But the DARE program that we had over here, I believe in prevention, and I believe in sustainability as far as the program is concerned. As much as we can do. The DARE program is a program that really works because it captures the people that when they are young, they are taught to be taught to stay away from drugs and avoid those kind of uncle circumstances that they would encounter as they grow older and stuff like that. So that really helped. During that given time, it really helped. Unfortunately, we had grants coming from the federal government, and unfortunately, we were just suspended out from the grant. But I found out that now there's a timeline since the time they took that grant away from us. There's a timeline, and we already got to that point where I think CNMI would be able to avail for that type of grant. And in light maybe at the end of the tunnel would probably also the court would probably be able to receive some of that funding. I know it's routed to PSS during that given time, but I think it's something that it's worthwhile for our community. It will prevent more drug issues and stuff like that. In prevention, and at the same time, we are focusing on the vision of our generation to come, and that is what I'm thinking right now. Since Judge Kim Tenorio is very adamant in moving forward as far as really trying to do all kinds of circumstances to try to help curtail these issues, community issues that we have. So that's the only comment that I got. But it might be a simple comment, but it's something to think about. And I look at your budget, and it's ups and downs. Governor's proposal and your proposal, it's only, it goes back and forth. So at the end of the day, I think as the committee and the general and all of us, the legislature, will look at it, and we'll see what we can do. How to, because we just cannot, yank out the cord out of this and stuff like that. We have to really consider an overall. When we make decision, we make it to the point where, it's fair for everybody. I am aware of the fiscal situation of the CNMI and the collections and everything that we get, but when we come to the table, then that's the time we will decide. Everybody get a piece of the pie. Thank you very much, Mr. Speaker, Vice
Thank
Chair.
you.
And
Thank you.
thank you,
Thank you.
all of you guys that are here today, judges. Si Diyos masi ni todo'y finatunmidyo sa no inagradesi loki. Sa sinya ben sagi mo ni sinya ben kubri hamzu zung loki ginisiran midyo. Lo maila da be faisinam jo tagini maila da ta fanajo da. Ang gindididia ginahata to pusta patin dididia. Ang ginmegay ginahata to patin megay. Enoa si Diyos masi.
Jesus Mossy, Rep Benavente. I guess one last one, Rep Castro, before we close out.
As a product of the DARE program, I just wanted to send a shout out and thank you to all the officers that were involved in DARE during my time as a student at San Vicente Elementary School, Dan, and then also a little bit of Hopwood. Those Jeep Cherokees souped up, and they were really engaging for the youth at that time. And despite federal funding may have a deadline, but if the program works, whether it's DARE or whether it's any other federal program that's designed to reduce recidivism and drug abuse, let's think of continuing it. The federal government already gave us the seed money to get it going, and if it's achieving the outcomes, let's continue. Look forward to working with any of the members of the judiciary if you need help in bills or earmark. You need someone to assist in that regard. I am one of your strong advocates, being a product of the program that Rep Benavente mentioned. Thank you.
Thank you.
Thank you, Rep Castro. And I apologize to the judicial team that our chairman had to step out, and I guess we'll be closing out. But as we get to the deliberation stage of this budget, we will work with your request. And I know that the priorities is to make sure that there's one new business unit and to make sure that those FTEs are placed back into the requests of the judicial branch, and then we'll work on the other stuff. I know that that it's going to be a challenge, but the judicial system or the judicial branch continues to push forward and be successful in its endeavors, even in these tough economic times. But it's an honor to this body also to come up with a good proposal or a submission, at least to the governor, for his consideration before we move ahead with the final product of the budget. And we will take your concerns and go with that process in our deliberation on the budget. So with that, I open the floor to CJ or any member of the judicial team to have the final word. Thank you, guys.
Thank you, Mr. Yes, today is a very important day for our people. And as Congressman Binabinti mentioned, if you look at the governor's submission versus the submission of the judiciary, it's really night and day. So I would say the million-dollar question today is, should we keep the doors open should we keep the doors of the courts open on Saipan, Tinian, and Rhoda, or should we shut it down? Mr. Chairman and members of the committee, that question, the answer to that question now is in your hands. And on behalf of our people, I respectfully ask that, yes, let's keep the doors of justice open on Saipan, Tinian, and Rhoda. Thank you, and PJ, go ahead.
I share that sentiment, Chief Justice. Let's open the doors of justice. Thank you.
Thank you, PJ. Thank you also, CJ, and thank you to the judicial team for making yourselves available this morning as we close out this budget hearing for the judicial branch. Please note that we will deliberate on this budget and see how else more we can assist with the request that you had submitted as to the comparison of the submission from the administration. So again, I thank you guys, and we adjourn at 12:28 p.m. Thank you very much.